9:30 on June 27th. I'd like to call to order the work session on the Special Committee on the Family Division. As you see in the calendar and what we talked about when we last met 2 weeks ago, this is a work session. We're not taking testimony today. We are meeting in order to assess what areas committee members might be working on in the next few months, because the committee, under House rules, will not be meeting again as a committee until September. So that gives us time to go through a lot of materials that have been submitted to us and also materials that we would like to read, so that we can come back in the fall again ready to move forward on what will be a report that we file. And the expectation is that that will be sometime before November. And there are obviously two major avenues that we can pursue. One of them would be, once we get past our general comments, would be a suggestion of legislation that we think could help the family courts better meet the needs of the citizens of the state. And another would be suggestions to the separate branch of the judicial branch, which is of course separated from the legislative branch, about areas that they might look into where we think there could be things that they could do in their jurisdiction that would again make the family courts best meet the needs of the citizens of the state. So that's our general plan. I want to repeat yet again something that has been said any number of times, but when people feel deeply about things, they don't necessarily listen because they're waiting to say what they want to say. And I want to repeat once again, under no circumstances, and never was it considered, nor will it be considered, that this committee will act as if it were a trial or appellate court to take any action on specific cases that have been filed and have been acted on, and under no circumstances will we be changing any decisions that have been made by the court. Those actions must be taken by the judicial branch if the judicial branch chooses to do so. The legislative branch is separate from the judicial branch, and we will do what we can to fulfill our obligations in terms of creating policy. And so I know that no matter how many times we've said this, people who are feeling deeply concerned still want to, still are hoping that somehow magic will fall from the sky and the judicial branch will take on, the legislative branch will take on judicial responsibilities, and we will not do that. We respect the separation of powers, and so I want everybody to be clear about that. However, we have heard a lot of testimony up until now from a range of witnesses, from people who are advocates, people who have professional responsibilities, and people who have felt that the courts have not met their concerns. And all of that we will now have some time over the summer to review and to think about and to learn from people's experiences. But I do want to repeat for what's probably the 30th time, we are not an appellate court. We are not a trial court. We will in no way be involved through this body in any review of judicial actions that would appear to be appealing or retrying cases that have been heard before the judicial branch. And does anyone on the committee have anything they'd like to add to that?
Yeah.
Representative Long.
Thank you, Madam Chair. Oops. Thank you, Madam Chair. So, yeah, I was looking for a report, but this special committee is not reporting out. We're just recommending legislation. So it's not even a report that we're giving out. It's our charge is just to recommend legislation if we see fit.
I think that's absolutely true, but as we all know, it might come to pass in the fullness of time that as we see how things have unfolded, it might be appropriate for us to set a context for what we're going to do. But I appreciate your comment, and it does, remind us that there are limits to all that we do or that we can do. Does anybody else have any comments? No? Okay. Since we last met 2 weeks ago, we were not permitted by the speaker to meet last week because during committee of conference week, there are so many things going on. The staff is so involved, and even the committee rooms are involved, so that regular committees or special committees cannot meet during that week. And so we did meet, we did not have a committee meeting, but those of us who had scheduling flexibilities some of us were able to visit family courts in 3 different locations: Nashua, Concord, and Laconia. And I believe everyone found the visits to be instructive, and it is always helpful to see for ourselves what the physical facilities look like, what the tone is, and we all observed any number of cases, some of us as many as 5 or 6, some of us 2 or 3, but I think everybody found that to be quite instructive. So here we are now, and the task before us today is to try to determine where we would like to spend our energies over the next couple of months individually, or perhaps a couple of people from the committee working together, but never more than that, because all our work is done under right to know, so that the full committee would never meet, or even the subcommittee would never meet in any venue that wasn't posted in the calendar. But there is a lot of research that we want to do and a lot of areas we want to pursue. And so I would like to know from my colleagues what they're thinking about. Representative Gregg.
So what you're asking, what we would like to focus on to work on each individual. So the GAL is a big thing for me, the guardian ad litem. I think that we have some work we can definitely do within that space, and I'd like to look further into that.
Is there something that do you want to develop that idea now, or do you want to wait and?
Well, I think while, there's a couple things that it's, that we don't fund it anymore, so that people, who have need to do it cannot get it. It's only for people who can afford it, which sets up kind of an unfair system in that. But also just looking at the GAL as far as, what they're not supposed to be giving recommendations right now, and they are lawyers. I would like to see, I've seen in other states where they expand that to have people with, psychological, degrees and backgrounds that are able to really look at situations, especially when we get into like domestic violence situations, and be able to be a little bit more knowledgeable as far as to all the psychology that goes into those situations. So I'd like to see if there's something we can, tweak within that to help the situation. Because I think, a lot of times it seems to be what we're looking at in these situations.
Thank you, Representative Gregg. GAL certainly has been an issue that has come up in a number of different avenues. Does anybody else have any feelings about that? Yes.
Thank you, Chairwoman. So I agree that the GAL issue does need to be looked into. I think we should expand it perhaps, or consider expanding it also into making sure that the qualifications of the GALs are really there, and that there is some sort of training to not have bias. Like, everybody inherently is going to have some sort of bias either way. And we want to make sure that if GALs are going to be looking into cases like this, that, we've heard lots of testimony about, people feeling that the GALs were unfair. And I think in order to mitigate that, there needs to be some sort of guidelines and training if we're going to involve GALs more, to make sure that they're not going to be just coming in and we're using them more, and we're having more and more people feel that there was a bias against them. And I'm not sure exactly how we do that. I do have a little bit of a concern with as well with the GALs, that in the majority of the cases that I saw, when a GAL was hired, they were ordering a mental health evaluation. And to me, that shouldn't be the standard of care, so to speak, that we're automatically ordering a mental health evaluation. Yes, parents are coming in, they're emotional about their children. Of course they are. It's their kids, their babies. But that doesn't mean that they're mentally ill. And I feel like there's this presumption that we need to rule out if they are or are not mentally ill. And those are expensive evaluations that people are subject to. And when you think about it, when I was looking through some of the data, because it's not medically necessary, it's not covered by health insurance, people are paying for these out of their own pockets. And it's like at an expense of $4,000. When you consider that there's a decent amount of people that only make $40,000 a year, that's 10% of their yearly salary to pay for this mental health evaluation that's very much so probably unnecessary. Unless there's an actual evidence presented, I don't think that should be a standard that's just ordered. We're going to order this mental health evaluation to rule it out. Unless there's actual evidence that somebody has some sort of issue that needs to be further explored, I do have great concern about that area of it as well. I'm not sure your thoughts on that.
Representative Gregg, if I could just for a moment, Representative Macbeth, we're starting by talking about areas that we think we would like to focus some energy over the next energy over the next few months, trying to go through the myriad documents that we have and figure out ways that we might help make sure that we have the best possible system. And that's what we're talking about now.
Thank you. That's a good
Representative Gregg.
Hi, thank you. I guess people didn't hear me earlier with what I was saying because I was talking sideways. Sorry, learning curve. So what I was saying is I would like to say this, and then I'll respond to my colleague, but that on the GAL system, I'd like to look into that, because I know there's other states where they employ, rather than just lawyers or people with legal backgrounds, people that have psychological backgrounds to do this kind of work, so that the complications of domestic violence and stuff are a little, it's not so obscure or whatever. They have a background, they have knowledge to what this looks like, because there's many times when, it could be the actual abuser claiming to be a victim and stuff. There's a lot of complications when it comes to domestic violence. So as to what, ordering mental health evaluations, I think that's part of, kind of goes into this. That's one of those things. I don't think it's necessarily that they're always, in the cases that I looked at, doing it because they think somebody's mentally ill. It's that they're trying to understand a background. I know a lot of when there are domestic violence and there's a parental rights evaluation or whatever, they'll do like an evaluation of both parents because that's kind of how you work to tell not if somebody's mentally ill, but if what the underlying issues are so that they can best evaluate like what's going on with the kids and stuff. But once again, I think that's one of those things with this GAL that's a little more specific than what they're really necessarily designed to do at this time. So I do agree that that's something that we kind of need to look into as to how they're doing that. Thank you.
Representative Macbeth, I don't want to put you on the spot, and you can say no, but I seem to recall that you have given us the clearest definition of the two different tracks of GAL that exist in the state. Is that something that you're prepared to share with us now, or would you rather not?
Thank you. And I would like to just mention, I think that, I think the GAL process, thank you. What Representative Smith is talking about is the different tracks between the guardian ad litems that are certified through the licensure office of licensure, and the GALs that are CASA volunteers. So I don't know much about the CASA volunteers. Prior to about 10 years ago, the majority of the guardian ad litems in New Hampshire were those ones certified by the state going through that training. And I understand there is a connection between the two and some separations as far as how they're disciplined but anyway, but when the state stopped funding guardian ad litems for family cases where the clients were at some percentage of poverty level or whatever, that's when the state then relied much more heavily, and there was this more, more leaning on the volunteer causes, what are they? The children advocates. I do see some differences in the groups, and I want to become more educated about that. But I know as a guardian ad litem, and I'm one certified by the state, and in the family court and the superior court and probate court, my role is a fact finder for the court. I know that I hear when CASA volunteers talk about their role, they're a voice for the child. So there's a little bit difference in that, and I'm not sure how much they commingle and if our language is just different. But I know that, of course, the minors' welfare and best interest is both of ours number one concern, but depending on the age of the child and also some of the psychological why if they may be influenced to say one thing or another, their opinion, while if it's obtained, it's generally shared with the court, it's not the end all. I just want to say, and I'm interested in some of the documentation that Representative, or data that you've looked at, Katab, about the mental health evaluations. My experience is when you get an appointment to be a guardian ad litem, the judge signs off and checks very specifically what, if you're a guardian ad litem, and I believe it's for CASA as well, what you can look at. So my appointment, I can only address, or I'm to only address those issues that the court has checked off. And in my, again, we're talking, I don't know what the percentage is, but only a small percentage of marital cases have guardian ad litems, or I don't know if you know what it is. I don't, but I know it's not the majority. And they're also, when I get them, they're usually very difficult cases that have gone on for a long time. And I would say just maybe in half of those does the court suggest that I make a recommendation or look into the possibility of whether a psychological evaluation was important. They are very expensive, and sometimes people can't get them because they're not indicated, and I think that's something we need to talk about judges if they are, but if they are checked off on that form, and I'd like to know how frequently they are, because my experience, which is just me, is that they're not rarely checked off, and even if I have some background, the judge always, is free not to take my recommendations or my I don't, again, I'm supposed to be a fact finder. So I list facts why it might be appropriate for the court to recommend this. I generally don't say this parent needs one. That's what the court, and then the court weighs that. But I think the other issue is someone, mental illness is a pretty big umbrella. And I think that having that evaluation is critical for the background. It doesn't mean that you can't be a parent. It just means, are you being treated? And because I think the majority, I don't know, I would, certainly in my family, more than half people have mental illnesses, so at one time or another. So I don't think I think what we're looking for is not necessarily a mental illness, but maybe that as well. But I think it's a broader just terms, the psychological makeup that might be causing some reactivity or conflict or something like that. But I guess I just wanted to put that in my experience, that someone having a label of a mental illness, which can be depression, ADD, I'm taking all that stuff, that doesn't preclude you from being having parenting rights, in my experience. If it's an untreated, if you have some type of schizophrenia, something that's untreated, or even ADD maybe that's untreated, and you never show up for parenting or whatever, I'm not saying, but I think that's what the court is looking like. Is this person following through on the treatment plan? Are they going to appointments, that type of stuff. So I just don't want to give mental illness a kind of a bad name. And I again, and I'm sorry to come in late, but I would really like more education, and I think parents need more education in the courts on these two different tracks of GALs, and I think we should have the same type platform and education and training, and also expectations of what we're going to provide to the court. And I'm not clear that that's always true, and I think that would be critical to give families a more transparent and consistent experience, because again, I see there is a dichotomy in my limited space, and not better or worse, different. And I think that then makes the experience different. And again, I think the big thing about family court is managing expectations. And if people have an expectation of their attorney or the judge or the GAL, and it's not what's happening, what I've heard from the testimony, that's generally what causes a lot of problems. People are expecting one thing and get another, so I do agree. I think this is something to look at. I also, the issue of, I don't know if you've mentioned it, but the issue of one parent paying and the other one not, that's an issue. I'm not sure why the state decided to stop funding these in the family court. Now, it still funds GALs, guardian ad litems, in the probate court and in the superior court to a certain extent, again, to financially needy people. So,
Thank you. Yes, Representative Lanza?
So not only do, as I say, after visiting the court in Concord, the parenting visitation centers, I feel like somehow they need to, I guess we've closed a lot of the centers throughout the state. And I think somehow those need to be possibly looked at and figured out if there's a better way, so that parents have the right to see their children when they're able to, and in supervision.
Representative
Capacity.
Lanza, do you know who paid for the parenting centers?
No, I do not.
Before.
Jim.
Was that in part of because I'm not familiar with that, as part of the judicial branch budget? Or is it part of DH?
so my understanding is they were independently owned. I don't know if they were licensed by the state, but the visiting parent had to pay, and that was also a high, it was expensive for people. I don't know if the state ever did run any. I know that they've closed down. I know there was one in Portsmouth that was operated by a guardian ad litem and an attorney, and it closed down too. 2 years ago or 3. They're just, I think they were very expensive to have. You had to have two entrances, an entrance for the child to come in with the one parent in a waiting room. You had to have the entrance for the the parent that was being supervised. You had to have a play area for them, and you had to have a glass window that was, so somebody could be supervising, and also audio so they could hear what was going on. And sometimes you had to have an individual in the room. So it's an expensive endeavor, and I don't believe they were state funded. There may have been some money, but from my understanding, they were private contracts.
I think the liability too.
Liability.
And I think we all know historically that there was an incident.
So I didn't know a lot about it, but what I'm heard from a lot of the parents is just that it seems like they're having difficulty um, finding a place that they can actually change off, even with transporting a child into the other parent, and then also needing supervision, and sometimes they'd have to go to a police station with the child, and I don't know if that's the most appropriate place for the children to each time have to have that happen. So I was just thinking for the children as well. So
You know what troubles me about this is this something that the concern is legitimate? Is the solution something that belongs to the judicial branch? And I don't know the answer. I mean, I don't know the answer. Representative Cauta.
So I'm not sure about that, but I do have a lot of concern about expanding the visitation centers, because I do think in general that if a family member can supervise, if there's a parent that, there is actual evidence that they may be of, potential harm to the child, I think that the least restrictive environment for that parent to visit with the child is ultimately what's in the best interest of everybody. And if that means having, a grandparent of the child supervising the visitation or whatnot, somebody that's familiar to the child in a familiar environment, I think that that's much better for the child to be, with known people than for and regarding like the exchange off, I hear your concern about the police station. I've always, taught my kids, never to be afraid of the police or the firemen or whatnot, because I want them to know that they can go somewhere for help. Yeah. No, but in the sense of, I don't associate like going to the police station with trouble. I just associate it with, they help people. So in that regard, I don't necessarily think that it has a bad connotation of exchanging there. I know a lot of parents who do exchange in the beginning of their divorce at the police station, just because they're high conflict and they like that there's security cameras outside of the police station. And if there were to be some disagreement, that they know that there's a police officer inside. And I've asked, at least in my town, if the police station minds, and they don't mind at all. If somebody feels, more comfortable exchanging in their parking lot, they're perfectly fine with it. They don't have any issues with it. The parents aren't actually going inside. They're usually just exchanging the kiddos in the parking lot. So I would kind of be more in favor of not necessarily going. I think the, the visitation centers take away from the parenting that the parents actually can do, because they're in, this kind of sterile room, so to speak, with their kiddos. And is that really great parenting time with their child?
Representative Long.
Thank you, Madam Chair. So Representative Macbeth and I witnessed a case where in the final decree, the one of the parents was to have a LADAC evaluation. And the party said, I didn't even look at my final decree. Now, the other party was concerned about visitations because of the drinking, and why they separated. And the party was still concerned about the drinking, and 3 months have gone by, and the children have told stories of what's happening when this party is drinking. So there was really no fix. A supervised visitation could have been a fix, because now, the judge recommended that you get a LADAC evaluation ASAP. So in the meantime, until the next hearing, the children got to go to the other party, with the other parent being concerned of the drinking. So I think, and I know in Manchester, the Manchester Police Department is called often. If the parents are gonna meet in the parking lot, they call the police department and they ask for somebody to be there, and if they have somebody available, they'll have them there. And that has gone, instead of having to meet at the police station. So they have done that. And I'm wondering on mental health evaluations, is that always a a clinician that's doing those evaluations always? It's not, okay, so there's no other way. So it's always because the LADAC, I don't believe they're clinicians, are they? LADACs,
I don't.
they're
I don't know what
licensed-
a LADAC is.
they're
I'm sorry.
licensed alcohol and drug
Okay. But I mean,
counselors.
if somebody hasn't actually been found to have had an alcohol problem in terms of they don't have like a previous DUI or something like that, I do have a little bit of a concern about how much presumption we're taking that they can't see their kids, you know, like, and I do know of cases where I have been alcoholic parents where they had supervised visitation by a grandparent. The grandparent slept over at their house for the night and supervised transporting the child back and forth. So I think even in those cases, it's still, the supervision still could be done, you know, in a less restrictive environment than in a supervised center. But I mean, I guess to your point, if a police officers are willing to meet in a parking lot, they're standing there. I mean, a police officer is trained to know if somebody is intoxicated or whatnot. But I don't know.
Obviously, there's a lot of questions about that. Oh, Representative Ball.
Thank you, Madam Chairman. So I just wanted to kind of circle back to the CASA. I was trained as a CASA. It was many years ago, and now coming forward to the conversation we're having now, the child that was removed from the parent was removed because drugs were found next to the crib, or another time because drugs were found next to his car seat. However, because the 10-year-old sister was not in the house when the drugs were found and was not in the car when the drugs were found, she was not removed from the parent. So it's interesting that in this case, when you have a parent who's drinking, but there's been no allegations of them driving with the child or putting the child in harm's way, we're going to use that as a reason to lessen their visitation or require a stronger visitation, when yet when we are looking at the other court, that's not a reason to remove that child from the home or from the parent. And then just to go back, CASA is, at least when, and it could have changed over the years, but when I was trained, I was to be a voice for the child. And I went to all the meetings, and I went to the house, and I looked at the house to make sure it was safe. But I didn't give any opinions, although I was asked what, you know, is a child safe and whatever. But I just wanted to clarify that. Thank you.
Representative McBeth.
Thank you. So one thing I'm really struck by is the overlap of, we've got the police and we've got DCYF, because as far as removing a child and just removing one, that would have been not the courts, that would have been DCYF, I believe. We've got, you know, the Office of Licensure and GALs, we've got the judicial, and there, I think some communication, I think that looking at the 10,000-foot view, some type of coordination and best practices, and really talking. One of the things I'm struck by with some of the anecdotes that we've got here, and again, and I really resist anecdotes, but the thing about the police station, I've had some parents, I mean, they say it's just like going to school. The police they have a drop-off lane. You can either do it for kids or Amazon, you know, not Amazon, but Facebook, or, I mean, I don't mean to make light of it, but it is something that is monitored. It's a lane that monitored. The police, you don't necessarily call in, you know, it's just something, you know, that safety is there for you. Someone's going to be watching, you know, the windows there, versus places where you pick the police station, but you don't know whether they have cameras where you're parked or whatever. So I think that's what I'm talking about, maybe coordinating this, because I know as far as, and the courts, when I do a parenting plan, I ask the parents what time is good, and if they don't know, then I just pick a time. You know, what would be good for me on Friday night to change or Sunday night to change? I just thought, wouldn't it be great? And then the court looks at the parenting plan and, you know, makes a decision. But wouldn't it be great if we talked to police stations, if that's what we're going to be suggesting people do a transfer at, and say, you know, what time of day is good for you? I mean, it still has to be good for the family. I'm not saying that, but the other thing I wanted to, again, this is my experience, Representative Katab, and I'd be interested, because it sounded like you had some data as far as what guardian ad litems were recommending and stuff. It is only in the most severe cases that these supervised parenting centers are being used. And I'm talking about when, you know, I mean, you know, you've got several different parents involved, parents, maybe a biological parent that's now lost their, but addiction, children, people that, okay, I'm just going to say parents that have tried to commit suicide with their children in bed with them, people that have been convicted of assaulting their child and breaking a bone, and then people that are in active addiction, trying to get help, but they can't. And so having the drugs that were mentioned here, and we have so much of that. And grandparents, a lot of times family, have already done that hands off until you're in treatment. So you don't have family members that can. And, the bottom line is, what a lot of counselors and people know is that if a child loses all contact with a significant adult, a parent or a grandparent that has been in their life, they can suffer significant, issues later on. So it's not just this parent's right, it's really the child's right too, to not have that withdrawal or that, alienation that does happen. So, I mean, and I do support the parenting rights. I just want to say, I also, as a guardian ad litem, look at everybody's rights. I mean, and it is the child's right to have still maintain that contact in a safe place. And it can only be every 2 or 3, whatever they can work out. So, but I would be interested, and I don't know if there are data, because it sounds like you might have had some about the mental health recommendations in these, but again, and to Representative Long, I don't know who would have represented somebody, but I had someone that didn't do their LADAC, and they kept telling me they would, but it's like 6 months, a year to get them, not only the cost. And so they went online and got one, and it was someone that had, I don't know if it's a PhD or it's a higher level. I'm not sure exactly. It's a mental health degree. And they were able to get it online, and I was impressed that it was thorough, but again, it was, $2,000 out of their pocket. So I don't think courts are over recommending it. In my experience, it's always beneficial, because I think that you can see basically we're looking for untreated things. Are you treating? We take people as they are, but are you doing the best so that you can have the parenting skills you need to keep a child safe and meet their needs? So, thank you.
Thank you, Representative Macbeth. I need the committee's help. We are living in a world where there is a great deal of misfortune, a great deal of tension, a great deal of concern, and the arena is huge. But here we are trying to look just at the family court. The family court can't possibly solve all the problems that families are experiencing across the country. And yet, just in the examples that we've talked about, we have the family court, we have DCYF, we have Health and Human Services, we have the police, we have trained professionals. I mean, all of these people outside of the court. Certainly the court's decisions can't make everyone happy, although by and large, they do manage to manage the majority of cases. Not all the cases by any means, but certainly the majority of cases. We could struggle to create a more perfect union, but we're not likely to achieve that. So what I want help with is, what can we focus on that involves the family court, where we can focus our energy? And part of that might very well be to make clear that it isn't the family court's responsibility to act as if they were DCYF, for example, or as if they were the drug institutions. It attempts to, address drug issues. they have to engage, obviously, with all these other factors in the society. But what can we focus on at the family court where their piece of the action, so to speak, is given all the due regard that it deserves and the support that that the state is obliged to provide because we have an obligation. Representative Ball and then Representative Cotto.
Thank you, Chairwoman. Sorry.
It's okay.
I respectfully agree with everything that you just stated, and I humbly put forward the recommendation that we start in the middle, kind of where everything is going right, and we have 2 fit parents, and we take the lead of 6 other states that have put forward equal parenting. And we look at that as a serious way of addressing at least that portion. Everything else that starts moving to the outskirts has to be dealt with, but we need to start with the presumption that we're going to have 50-50 parenting when both parents are fit parents. And I think that would help alleviate a lot of the animosities that tends to come into the courtroom when people are very afraid of losing their children, access to their children. But respectfully, I would love to see us start at a center point and then start moving away. But I do agree with you that the family court is responsible for that portion, and the other thing should be moved out to other agencies. Thank you.
Thank you.
We do now have 50-50 parenting is where we start at.
Hi, may I respond? Actually, we have a try to make it as equal as possible, but it is not necessarily 50-50. And my experience has been that in some courts it happens and in other courts it does not. But it is not a guarantee that we start with a presumption of 50-50.
So I actually asked that when we were in the Nashua court, specifically directly to the judges, and they did state that typically they consider what's in the best interest of the child. And if you look at what the RSA is, and they specifically said that they do not start with a presumption of 50-50, and this is directly from 3 judges at the Nashua court. So if you look at the RSA, it says, in determining parental rights and responsibilities, the court shall be guided by the best interests of the child. And when it goes into it does say that like each parent shall have they should promote allowing contact with each parent, but it doesn't say anything about equal. So I do think that there is a key difference in actually a presumption of equal parenting time versus just continued contact with each parent, like an actual, are we going to try and as reasonably as possible do 50-50 versus is it just time with each parent? I think there's a huge difference between that.
So I think that
Excuse
I
me.
go,
Are you finished?
She can, yeah. That wasn't what I wanted to go back to, but yeah, go ahead. No, go ahead.
I was just, I think I stand corrected. What I think is, I think what the court is both parents are equally considered for being their parenting. It doesn't start off. So I think that you're right when the judges said, no, we don't start off at 50-50. We start with a flat slate and then we go. But there's not a bias that it should be anything. But I do think the presumption is both parents start out as equally fit to be parents. So I think I probably overstated the 50-50, but.
Representative Gregg.
So that's one of those complications that we've talked. Oh, sorry. Thank you, Madam Chairman. I always appreciate you. Sorry if I forget to say it. It's one of those things we've talked about a lot in children and family law because it's something that certainly comes up. The dilemmas that we continue to hit is for 100 families, we have 100 fluid situations. So to say that we're going to start with having this particular part of the puzzle, we're going to try to throw everybody in this is complicated, especially when there are so many things underlying in situations. I'm going to go back to abusive situations because we do have a high population that have domestic violence in our particular state. And so, you know, when you go into things like that, to say we're going to start with this, it leads to a lot of different things. We've heard from, you know, Waypoint, we've heard from other things that will actually keep some domestic violence victims in their situation, thinking that, well, if this is on the books, that it's 50-50 immediately. And by the way, I've not come across one survivor that doesn't think that, you know, they're going to lose their kids because they've been told that the entire time as soon as you go, or that doesn't think I'm managing this at home right now as soon as the other person can have the child without supervision, what that does. So that's just one complication. Representative Long has brought up a really good point too. When we start 50-50, what does that look like, equal parenting? You know, a lot of times the court says, okay, well, it makes sense for them to be with, you know, one parent during the week because, you know, they're at school, this is, you know, their routine and stuff. So what would that look like 50-50, like 3.5 days and all of a sudden they split? It's just it's one of those things that I think it sounds really good, and we want parents, especially well parents, to have as much visitation as possible. And I understand the reason to say it is because there are parents who have not had any contact. But saying automatically, like, we have to do equal parenting immediately doesn't work in actuality, because then you've got a parent that maybe goes to work at 5 a.m. So what does that mean? The child has to get up because it's 50-50. We have to have 50-50. Then that child gets up. It's just complicated. Like, it's one of those things that I think by fixing a few situations, we can make a massive, we would regress on other situations because it sets that up there. So it's just very complicated to put something that black and white on the books.
Representative Coe.
Thank you. So I wanted to kind of go through like a list of ideas that I had, and I do want to, circling back to the 50-50 custody thing, I do think that if the presumption was that it was going to be 50-50, unless the parents agreed otherwise, I do think that there are a multitude of different situations, and there would be parents that would come into it with an open mind that, okay, we need to do what's best for our kiddos because we know that the presumption is going to be equal parenting time, but I have, you know, a 3 to 11 shift and the other parent has some other shift. I think that they would come up to what works and makes sense for their own family. I really think that there would be more people that would come together to figure out what would work for their family if it wasn't so much of just fighting to get any time, but it was, okay, we're going to have equal time. How can we actually make this work with our work schedules? So I do think a presumption of equal time would actually lead to the parents working through things more. I also think if the child support were to be fixed, that would be really helpful. Right now, there can't be like any kind of, the guidelines are not really in a way that's workable. So I think if one parent is being ordered to pay more, you can't, just because there's more parenting time even with another parent, it doesn't mean that other parent has to pay less. I think, to me, what would be fair is when you do up these child support worksheets, if say, you know, parent A, it says the cost to raise a child is $3,000 and parent B, the cost to raise a child is $1,000, you take the difference and you split it in half. So that means that each parent is now going to have $2,000 to raise the child. If you just take the difference and you say, okay, parent A is $3,000, parent B is $1,000, and you take the $2,000, then you've got parent B having $3,000 and parent A now only has $1,000. So I think we do need to consider those guidelines. I think also another area that we should really take a look at is timelines. So we have timelines for some things and not timelines for others. And I think if we had a more clear picture of having timelines for things, it would be better. I know we just expanded under SB 180, is it 189 or 129, mediation for those who can't afford it. And I do think if we had kind of some better timelines in place, we might be able to work through things. The other thing that might be nice for us to look into a little bit is expanding the neutral case evaluation. I know that's currently only offered in Concord. I think if it were offered in a bit wider net, again, like I think nobody knows what's best for your family than your own family. You know what your children do, what activities that you have, what schedules that the parents have. And so if they knew like, hey, if you're going to go to court, then the judge is going to decide, and nobody is going to be a winner because he doesn't know all these intricate details of your family. Let's try and work this out. And you've kind of got the neutral case evaluator saying, well, if you go to court, like, no, you're not going to get your whole list, and you're not going to get it either. And it might be bits and pieces that weren't even priorities for either of you. So let's just try and work it out together. So I think, that is one piece that I'd also like to look into. And then I'd also, within the timelines as well, like kind of circling back with that, like I think if we did go back to that one judge, one family, that it really would help a lot. I think where the timelines are so spread out right now where, we've got some things that are required to be done with a certain amount of time and then some that just have no end date in sight, that judges are retiring or moving on to another office. And then we've got a new judge coming in that is completely unfamiliar with what's going on with the case and trying to read back through. Think about some of these families have gone in for motion after motion, hearing after hearing to try and read through all of that testimony and whatnot. It's just not efficient for a judge to have to kind of reread through all of that. So those would kind of really be my key areas that I would like to suggest.
Thank you. Let me ask you a question about this one judge, one family. One of the issues that I heard again and again as we listened to witnesses was what seemed to me to be a confusion between the domestic violence issues and those other issues that get you into family court. And we had people testifying who expressed their distress about a decision that a judge made, and then I realized it had nothing to do with the divorce proceedings. It had to do with domestic violence, and that the primary participants didn't seem to understand the concept of the difference in jurisdiction and in responsibility between those two avenues of the components of the judicial system. So when you have a particular family with issues of custody, issues of parenting, issues of domestic violence, who's the lead judge, and what is the determination about who follows, given also the fact that the judges act not necessarily regularly, but certainly do act as if they were circuit judges, and so they move from one court to another. So the ideal might be one judge, one family, but can that work? In order for that to work in practice, do we have to change by legislative action, or do the courts have to change by judicial action the way cases are assigned, the way judges are assigned? How do we find our way into that Gordian knot? So I hear what you're saying, Representative, and I think in theory it's terrific, but is it workable?
So while we did hear about a lot of domestic violence cases here, I think that the percentage that we heard from relating to is much higher than what is actually in the court. So I'm going to look to you if you remember off the top of your head, Attorney Pratt, but I believe we were told that there was roughly 30,000 divorce cases per year. I'm pretty sure it's roughly 30,000. And the number of the number of domestic violence and stalking petitions that are filed per year is just shy of 6,000. And so even if all of those 6,000 were part of these 30,000 divorce cases, that's 20%. And realistically, not all of these are obviously part of divorce cases. Some of these are people that were not married and do not have children. So while we did hear a great portion in here, I think it's important to note that the majority of the cases don't involve domestic violence in them. And so from that perspective, I do want to caution us on not, although we've heard from a high percentage in this particular committee, I do want to caution that I don't think that that's the general percentage. And you may know better, Rep. Macbeth.
Actually, I had a question for you, Representative Katab. So what percentage of cases are not one case, one judge? Because we've heard that here, but again, that isn't my experience. My experience is the reason we have a different judge is because someone comes in with an emergency motion. Generally they are, but I don't represent, so do you have statistics on how many people don't have one judge? Or are we talking about the people that the witnesses we've heard from here? Certainly we've heard that here, and I have too. I'm not challenging that.
So I asked for some of that data. There's a little bit of trouble with getting some of the data because some of the data they just don't have. I did reach out to a few different family law attorneys that just are friends of friends. And they did tell me that they've had quite a bit of turnoff with judges switching different locations and with getting different judges. They said that they would say even in about half of their cases, they've ended up with a different judge. Pretty high percentage. I don't know if you've maybe lucked out in one area where they
No.
didn't, or
And I'm wondering, so I think that's very interesting. So I think it would be interesting to know if these, why judges changed. Were they moved by the court? Because I know they reassign, or did they retire? Or was it just that's not the priority of that area? And might also be interesting to know which areas are having problems with that, because they are, they're very close to the ground, so they're very sensitive to what's their neighborhood, their community. So it would be interesting to know if there are certain, if it's not happening in some places. And how do we change it? Is it more judges? I mean, we talked to a judge, and they don't have any writing time. So, for them to get off the bench to rule on some cases, if they're scheduled for things. I mean, it's just interesting how busy they are. I don't know if you talk to your judges. So in order to have one judge, one case, is it that we need to have the judges in the courthouse more time so that that judge is available when that case comes forward? Because that's generally my experience. I have had cases that have had, but generally it's when we didn't want to wait for them to get off vacation or, or something like that. But
I could
Yeah,
follow
we
up
heard
for a
that too.
moment on Representative Kotov on the questions that you asked. In the family division, in 2022, they had 7,054 divorce and parenting cases. They had 3,860 domestic violence cases. Then, the juvenile delinquency chins cases, abuse and neglect, guardianship of minors, and termination of parental rights. The termination of parental rights is 560, which would clearly indicate that that's a few cases of the most difficult, and that are the most difficult. But one of the things that struck me is while the budget that we just passed provides significant additional money for the courts, that nonetheless, the courts have, I think it's close to 40 or about 40 positions now that are unfilled. So if those positions alone were unfilled without the additional money, it would make a significant difference. And certainly with the additional money, it might mean that that some of the problems will have been addressed. I want to go back to something about training and supervision and accountability. The training that is offered is once a year. There's access to very solid national training. But when you look at the judges who are appointed, almost none have had experience in the family court. They have had experience in other courts, perhaps not. Some people get appointed having had no experience in any courts at all, because most of the work that lawyers do doesn't involve courts, although we don't think of that because we just think of how things are shown on television. So you get somebody who has no experience with family court. We all know how we struggle with how complex the laws are, how they change, how they're interpreted. If they have a week of training and then they're dropped in a court with a long caseload, what do we expect? I mean, what do we expect of somebody who's dropped in an alien culture and doesn't speak the language? And that is something that is of real concern to me. The executive branch is the branch that's involved in the appointment, and we haven't talked about the executive branch's role in this at all, but that is obviously, they're at the starting gate. They are at the starting gate for who, in fact, sits on the bench. And then we put these earnest, capable, committed people in the court who don't speak the language. What do we do then? How do we train them? How do we provide supervision? How do we provide accountability? That whole piece is something that, to me, is very important. Did I see your hand, Representative Long? Because you're more knowledgeable than I am
well,
about this.
No, I actually, that is one of the questions. Thank you, Madam Chair. That is one of the questions I ask. And I saw the two people that I've asked the question to faces get uncomfortable because I said that, is it political appointments? Is that the issue? I'm just trying to get to the bottom line of why this is all happening. There is training for a week by a national association somewhere in the country.
Nevada.
Okay. If they all could make it. So they don't all make it. So that was one of the issues. But with all this discussion, what I look for is a reduce in conflict. For example, the presumption of equal parenting. That'll clearly reduce conflict because I'm not fighting to see my child to how much I'm not going to pay. Is it complicated? Absolutely is, because I could see people fighting over, I want equal parenting because I'm going to pay less, right? It's not, we heard a lot of testimony that they felt like winners or losers, and we got to turn that into the child. Is the child the winner or loser? So reducing conflict, when at Children and Family Law, when I look at a bill, I look for that. I look to see if this will reduce or add conflict. So these are all equal parenting is great. The timeline I think is fantastic, knowing that my ex can't drag this on forever. I got to stop paying for an attorney and go pro se. I like the neutral case evaluation. Everything we do is going to be complicated, but we need to do something and then work on, because the conflict cases are smaller than, there's, I don't know, 70% of the cases that come through where you could get an agreement with both parties, is what I remember. So then you address the complicated cases. I remember Judge Foley coming before Children and Families saying, whenever I get a conflict case, I sit with the two parties and I say, you do realize that because you can't agree on something, I'm going to have to make that choice, and one of you is not going to like that choice. And I thought that was good. The more parents could get together with the best interest of the child and not one up each other, that's what we look for. And I think all of these in some form need to be, needs to come to the surface, and then work on addressing the complications. And the same with supervised visitation. I think Representative Macbeth said it best, that these supervised visitations are testimony that we heard of parents not seeing their child for a year or 2 years, 6 months. Why? Because they had a DWI. And the other parent's saying, when I drop him off, he looks like he's drunk. So as a judge, you're thinking, okay, that's a liability for me if I allow that child to visit, knowing that the person is an active drinker. So these supervised visitations during that period where they're trying to figure that stuff out, this is where these are used, so they don't stop for a year or 2 years or longer. So I think everything that has been brought to the table is quite a bit for the summer for us to be working on. I just also wanted to say the staff issue. I was blown away by visiting Laconia. I was blown away by the lack of employees. The 7 judges may help, but there's staff workers there making $16 an hour with stacks and stacks of cases that they got to review, type up. I'm like, how does this happen? So I could see a bottleneck that complicates, that creates more conflict, I think. A serious look at the financial standings of the judicial system, of the family division anyways.
Representative, oh, I'm sorry.
One issue that dovetails into this, but that I really see significant, is the number and the increasing number of pro se parties. And that ties in also, I think, with the lack of staff at the window to provide adequate, again, they're not allowed to provide legal support, I know, but just that they're not so overwhelmed that they can't provide the forms or the list. I know that the courts, we saw they have, really good, these are the forms you need. You need to fill these out. But, a financial affidavit is fairly hard to fill out if you don't have some support. And I'm not sure that we have the staff that can really provide the support that may be necessary for the amount of pro se people we have. One thing that I'm shocked about, and I think there was we had provided some testimony, and one of the witnesses, they had been defaulted on an issue, and they kept trying to go back. They were so upset about it. But I think also pro se people don't realize that it's not the doctor's office. You don't call up and say the day before, 2 days before, I want to change this date, or I don't feel well, I'm not coming in. I mean, if you don't show up at court, you can be defaulted, and if you are, that issue has been resolved. And we do that to protect our courts from having people just come back and come back and come back. And again, that's a small thing, but I think managing the expectation and the needs of our citizens that are pro se is important. And I think that also protects our judges, because I think people have testified, well, there's this law and it would have changed my child support or changed my parent, but it's not for the judge to bring it forward. And when that individual has showed me what they've done, they never brought forward, there is a statute, we have a statute that would have changed their child support or would have changed maybe their parenting responsibilities, but they didn't bring it forward. And, we can't. So we do need training, the training for the judges, I completely, but I'm going back to the number of pro se people we have, how to manage their expectation, educate them appropriately. I think the neutral case evaluation is critical. Mediation, as I understand it, it's what I like when I'm in a case is somebody to tell me, this is what's fair, a neutral person. Mediation really is just getting people to agree. The mediator isn't supposed to give a lot of dialogue on this is fair, or this is what the court, or this is how the cases come out. They're really just supposed to get you to yes. I mean, again, I know it's too simplified, but that's why the neutral case evaluation is so good, because they can actually say, you know what, this, I think, here, you're at 0 and you need to get over here to some 5 or 6, and that's really, some mediators do that, but as I understand it, really they're just supposed to get you to yes, which is, and I'm not belittling that, it is still very good to get people to yes, because some people are reasonable and they expectations, and that might work in a lot of cases. But when you have somebody that really isn't reasonable, then it's not for the mediator to tell them, Bob, that's not going to go. I mean, that's what I understand. Anyway, pro se people really concern me. Judges being there that want to and that are trained, and pro se people having the information and the staff they need to give them information.
So the staffing is an issue, and the dependence in the courts on, or the prevalence of pro se individuals does create problems. I know in the cases we observed in Concord last week, there was an attorney only, I think, in one case, and that was all. I also was surprised to learn that there are about a dozen different forms having to do with divorce, legal separation, petitions with minor children, parenting, and they're complicated. And it is my understanding that at least some of those forms come from legislative action. Is that correct, Representative Long?
I don't believe so. I believe it's the courts that make those forms. I don't recall ever, whoops, I'm sorry. Yeah, I don't recall ever voting on ever having a bill of a form coming before us.
Okay, so not any of the child support. Excuse me.
Yeah, well, I know we did formulas, but as far as the form was left up
Okay,
to
so it
judicial.
would be the formula, the underlying principles
Right,
that then are applied by the court.
right.
Excuse me, what? Yeah, that's what I'm curious about, that in fact, how much of those forms are based on any RSAs, and I'm not embarrassed to say I don't know. I mean, because we all know just a tiny bit of all of this. It's so complicated. I did hear a comment from one of the clerks that I thought was quite interesting, having to do with the financial forms. And the comment was that the forms all had to do with income, money coming in from whatever source. But none of the forms addressed the costs particular to that family of raising a child, whether there are specific costs that aren't covered by health insurance, for example, or whether the child is, going to be an Olympic skier and whatever. But are those costs in some ways borne more by one party or another based on when the child is with that party? And that occurred to me that that might be a legitimate question. And that's why I want to know what role the legislature plays in that. And I'm sure people who are more knowledgeable than I am would know the answer to that.
So I just want to respond that the financial affidavit in the family court, the third page is all what that parent and that household's costs are. And that is why I have asked for it from some of the people that have asked for the child support guidelines to be changed for different reasons, because judges look at that and they do determine whether they're going to deviate if you've asked for a deviation based on the maybe extraordinary housing costs some parent has or uninsured health, that type of thing. So I just want to say, I do think the judicial branch, you're not saying they don't, but that form that's definitely there. And it's definitely why I've asked for it from folks. And as of yet, I haven't gotten it from that gentleman, but that is what judges do look at. And one reason why I think our guidelines are good, I'm not sure specifically what the guidelines we want to change, but we do give judges the discretion to look at that, and also to look at, is somebody voluntarily putting 1/3 of their income into retirement or some type, so we can double check, but that is there. And one of the things that happens with pro se, I mean, that form is supposed to be submitted at every family hearing. It's supposed to be updated and submitted at every family hearing. And that's another thing about expectations. I think if you're pro se, I mean, the rules are difficult for me, and I haven't gone to a hearing that I haven't accidentally missed something. But when that isn't provided every time, then we don't have the full information. But
Representative McMahon, I don't want to put you on the spot, but I wonder if I'm interested in what your thinking is. If you have anything that you want to share now, you might not, about where you would like to see us go. I just value your opinion.
Sure you want to open that door? Your Honor?
I hope I'm honorable, but
Yes.
I don't deserve the title, Your Honor.
Well, Madam Chair, listening to our colleagues and the expertise that we have intrinsic here, excuse me, gonna follow the rules here. And listening to my colleagues, and also was going through the database that I have myself on the meetings that we've taken. One issue, and hearing today, there's a process that we've learned here, again, specific to family court, and is where have violations of the quote process or the interpretation of process taken place and then need addressing. And one of them was rules of evidence. And what has come in my view of this is something for us to consider and work on was when a court case comes before the battleground, if you will, then it's each defendant and a petitioner, are they fully loaded with evidence? And when I've seen read and heard in testimony, is that judges have a specific interpretive intent of what they consider legitimate or not, which is an opinion and not based on law, but what they consider as evidence or something that is pertinent to the adjudication of the action in place. And so what I saw here in this was that rules of evidence need to be addressed as part of enhancing the family court experience. Based on what has been discussed here, is that it's not followed, and it's interesting. We just had something else passed to us right now, and it says right in here. It says you'll see it on page 4 of 9. It happened January of 2023 in this court proceeding, where it says the court, when I say the court, I don't know who wrote this, whether it's a clerk or the judge, him or herself, where it says rules of evidence are not technically or strictly applicable. And the court construes, when the court construes a motion for reconsideration, that's what's happening here. That's what I have learned in my perception, and curious what other members feel, is when the petitioners do not feel they're being heard is because evidence is not being, are not allowed to be presented, or if it is allowed, it can be just discounted based on the opinion of the court meaning the judge, in the promulgation of the court case itself. So that's what I've learned on all this. And then what happens when there's when you're on a playing field, that your evidence will be heard. Then we go into then what takes place on action, like co-parenting and so on, based on what's the evidence before I decide on co-parenting. Not that there's a de facto predetermined result. It's what's the evidence that then says, okay, to 50-50. To me, that makes intrinsic sense. But it's based on what? And it's just interesting when I see evidence does not play a role. Well, then when compounded by professional attorneys, those who can afford them, versus pro se, and that's I went to the team of us went to the Nashua court system, and out of the five, is either 5 cases out of 5 out of 6, one didn't show up, but 5, 4 were pro se and 1 had an attorney, and all the attorney was doing was observing. What I saw, it was sitting at the table, but it was a judge asking, directly the individual. But anyway, my point, Madam Chair, was rules of evidence playing a role in what our and as Representative, as also the other representative stated, was that what we recommend as laws to be passed as to consider for for the court system. Not saying what the rules are, but what's the law for us as representatives to recommend for passage through I would imagine the Judiciary Committee.
Well, thank you for that comment. So the issue of rules of evidence, we did hear a lot about from people who have testified, and what to me was most clear, and in a way I think you supported that, is that pro se litigants don't understand the role that rules of evidence could or should play in court procedures, and what are the rules of evidence. I mean, it's not as if it's the 10 Commandments, and even then we have differences of opinion. We certainly have differences of opinion on what rules of evidence are. And so the question that you raise, I think, is a legitimate question, and the answer might be very complicated, or it might be as simple as finding a way to have pro se litigants understand the rules of evidence. Or it might be something much more specific than that. So I think that certainly is a legitimate issue, having been raised a lot in our hearings, to go on our list of things we might want to look into.
If
So
I may,
I thank you for adding that.
well, Madam Chair, ask your guidance on this one, and any other of our esteemed members, is and that's, I want to make sure I say it in the right context. There has been comments of implication that the judges themselves aren't competent and making their decisions. And this is where you get to the training, and competent in terms of dealing in the uniqueness in the family court, as opposed to a criminal case. We have dealing with family issues, and we'll stipulate what we've heard already. Is there from a training standpoint, is that something? No, that's something that's come up here that we should make also part of law that has been suggested here for those, and then enhance how they're paid. as well for folks to take on these cases, which are, there's, as we said, there's hundreds, thousands of them. But who's willing to take on, who's like a judge in the system and the staff? By the way, we have the staff there that really does a heck of a job, along with the judge's work on meeting these court challenges. And if we don't have the resources, then that what I've been reading when I've been reading what we've been provided is that there appears to be a facilitation to move things faster through, so that the cases are handled quicker and not necessarily to the best interest of either party.
I hear what you're saying, and I'm sure there are people who believe that, just as I'm sure there are people who believe contrary to that. You know, this it is we're a litigious country, and these systems are adversarial. We would like not to see them adversarial when they involve children and the well-being of families, but we tend to set things up with winners and losers and all those things that make it hard to just be nice to everybody. But we also have to, I think, remember that the people who have been diligent in coming to speak before us are very distressed, very, very distressed about what their experiences have been. And we also have to remember that as important as their experiences are, and we don't want to minimize that, they also are a very small minority of all of the cases that are heard and that go through, and people are reasonably satisfied, understanding that the world isn't perfect. So we also have to be careful not to be swayed by information that might be taken out of context. But I go back again to one of my major concerns, and that is recruitment, training, supervision, and accountability. And some of that is the responsibility of the executive branch, some of it's the responsibility of the legislative, and some of it's the responsibility of the judicial branch. And how this committee handles that, I don't know. But that's why I'm so pleased that Chairman Pearson, who was very sorry that he couldn't be here today, but is involved in other important business out of state, agreed that this session would be a work session so that before we go into the summer recess, we could begin to identify myriad issues that we'd like to look at more deeply. And I think you raised some important issues, and how we determine what is in fact the legislative responsibility or the responsibility of one of the other branches is going to be central to this. Representative Ball.
Thank you, Madam Chairman. The one thing, and I do agree with everything that you're saying, the one observation, a couple observation, we had some very brave people come to testify before us, but I do believe there are a lot of other families out there that are struggling, but they do not want to bring their case forwards because they're afraid there could be a retaliation or it be used against them if they have to go back to court. So they're trying to keep it a private matter. That would be one. The other is when we talk about domestic violence, I think that we need to be sure that we're separating how many cases were actually dropped and how many are actually convicted. I think, unfortunately, people involved in this can become very emotional, and they can be somewhat, I hate to use the word unscrupulous, but they will use the court in order to get what they want against another parent. And I'm afraid that that tends to be a little easy to do in the system. And I'm not saying it happens a lot. I'm just saying that there is a means for that to happen. And I think we need to somehow figure out how to close that loophole. One of the things that was brought up when we went to the Nashua court, and I was quite shocked by, is two of the cases that we listened to both times the children were allowed to be taken out of state. But there didn't, and in both cases, there didn't seem to be a mechanism to get them back into the state for visitations. And I was confused by that and very concerned that that was happening. And I'm sure there was a reason for it, but I do think that's something that also, if we are going to allow children out of state, we do need to make sure we're setting up a way so that the parent who is still here is not incurring financial hardships in order to try and get visitation with their children. Thank you.
Representative Macbeth.
I have a question for my colleague, Mr. Representative McMahon. When people are bringing or your own interest in having the rules of evidence in the family court, are they specifically mentioning which rules they feel are not adequately applied?
Not that on the reading I've done and the observations, when I even asked a question on that, there's not been a specificity. It's just the global statement that rules of evidence are not applicable in family court.
So I'm wondering, and of course, Chair Pearson would probably, that one might be a good role play for us, to be in court and see if we, being pro se, could get a document in, like a screenshot of your partner saying, I don't care, I'm going to drive him drunk because it doesn't matter. Because you don't, I can do whatever I want and I'm driving him drunk. So, if you had that screenshot and you brought it into court, I would be surprised if we had the rules of evidence in effect, if a pro se person would be able to easily authenticate that document and get it accepted. What we have now, when the rules of evidence don't strictly apply, they do apply. I mean, it's amazing because generally they are applying, but not in the strictest sense. But if you had that screenshot, the judge might, if they could say, do you recognize this? Is this a text you did? Is this, is this something, do you authenticate it that way instead of having to either have phone records or certification or just the whole line of questioning, have time and date. So I think we heard from some of the officers saying that I do it so people can get stuff like that in. So that's why I'm wondering what rules, are people upset about? The other thing is when you, if you hearsay, I mean, can you not say, my 10-year-old told me, her mother put an iron on her, well, no, you can't, because that, what I mean? That's the rules of evidence are going to apply. That's, it's hearsay. You can't bring it in. So I think that's why we in New Hampshire have allowed them to be lax, not strictly or technically applied, because they do apply. But I really, that's why I'm wondering what rules, all of them or some of them, and what would really be the impact? And I know that for me, as a practitioner, I don't get stuff in because I don't know the rules well enough of evidence, sometimes. I would be concerned with the amount of pro se people we have. But if people are specifically talking about certain rules that they have a problem with, I would like to know that. And that would be helpful, I think. And that also goes back to maybe educating people that are pro se in the front end. This is, you're going to be held to this level of performance, or you're not going to be able to bring in stuff that, so you can't bring in a doctor's report that's just a copy of what they've given you. That's not going to be okay. You can't bring in an attendance records that's just a copy. I mean, you'd have to, if the rules of evidence applied, it's got to be authenticated properly, a proper foundation laid. So,
Excuse me. Excuse me. Thank you.
Okay, if I may offer something to that, I understand what you're saying as part of the, considered part of our narrative that we've heard here as our committee. And one thing I've learned here, before getting to where the judge is making decisions on what has been heard, we have the two other avenues, which is mediation, and then the new one that I learned, I think, with other members, was the neutral case evaluation alternative before, or hopefully not needing to go to the authority having jurisdiction, being the judge. But notwithstanding that avenue, and that's where pro se, I would say, has much more influence because they're on an even playing field, in terms of trying to come to a cooperative collaboration to achieve consensus. But before before the judge, it was been and I'm not in front, I'm in front of the judge, I'll stipulate that that has not been the case, I'm happy to tell you. But the fact is, it's either you're a dog or a cat. And do the rules of evidence allow? The answer is no. By allowed, meaning they're not pursuant to family court cases. And and what I'm suggesting we consider in our discussions, cross that bridge to say rules of evidence shall apply, and here's what the rules of evidence specifically are. So there's no misinterpretation of intent. And that's just what I've learned here and then to hear this case we just got a copy of that says it doesn't apply. And so if I go in there, am I fully armed in my particular case, or is it based on if the authority likes me that day, or did I say the right word that day? Not dealing with evidence, but how I present the case on either side in family court. And that's what I find to be of how do you not level the playing field, but can we get on the field with equal access to the tools to advance the positions?
Representative Cota?
So, following up on that, I think one of the things that we did here regarding the rules of evidence was really people wanting to have the discovery regulations enforced so that somebody couldn't spring evidence on somebody that they hadn't previously seen. And it seemed like, and I did actually hear this, and I don't know, Macbeth, if you've experienced this, but I've heard from some attorneys as well that, sometimes the judges are very strict on that you needed to meet the timeline to give your discovery, but then sometimes they're more lax about it, where if it was due 10 days before and you gave it the day before, you're going to be in trouble for that, versus sometimes they just ignore it. And it depends on the day. It's not even necessarily the judge. Have you experienced that? Because that is something that I also heard as well, like with an issue.
I don't think I've experienced that wild swing, but I think I've heard complaints from testimony, people not being allowed to provide their, make their argument or whatever. They were cut off by the judge, but they didn't bring it before. So, I mean, and I think also that's a good thing about one judge, one case. I mean, if they've been working together and they know that this guy's always, or this woman's always a little bit late, like I'm always late. I don't know what's wrong. It's this phase of my, they may, I mean, they have the flexibility to work with that, but no, I don't see the wild swings that, I think they're pretty consistent. And I think what they generally do is try to like the parties, if it's 9 days or the day before, they've both done it like that one person hasn't had and you can always, if you can always request a continuance because you haven't been able to provide that information, but you may not know how to articulate that if you're pro se, and you may not also know that they've got to hold it 10 days unless you get the other party's assent. And they, so there's all those things. And I just want to say, I am going to bring rules of evidence. I mean, it is not a one pager, they might have it at Kinko's at one page, the rules of evidence, but it's a significant document that has been interpreted by, practice and by case law. So anyway, but I haven't.
First, Representative Long, we haven't heard from you in a while, and then Representative Gregg.
Thank you, Madam Chair. So the rules, we have heard specifics on evidence that wasn't allowed. However, it's hard for myself to determine why the judge ruled in that case. The fact that judges are interpreting differently was an issue, and that's a question I asked, whether there's any career training after 3 years, 4 years, 7 years of being a judge, and there isn't any. And I know in children and family law for years, we've asked judges to attempt to get on the same page on bills that we've been hearing, and that has really never come to fruition. Because we hear a lot of this judge said X, and on the same type of case, this judge said Z. So it's training and continued training.
Thank you, Representative Gregg.
Thank you, Madam Chair. So, in just sitting here listening, I'm contemplating, this is so complicated. Family cases, even one case is incredibly complicated. But the common denominator that keeps coming up when we have issues with cases is the pro se. Obviously, we can't expect, this is why in criminal court, you have attorneys assigned. We can't do that in family court. It's not practical. So I think one of the things we can do, and, is, we can just recommend. Obviously, we're not the judicial branch. I have a great respect for the judicial branch and all this work that they have to do. But is looking at there, and I did not take the time that day to look down. And if we're pro se, we saw the computer where they can log in and do all the things to see what that is. There are national recommendations on that kind of stuff, like as to for the court systems as to what you could do as pro se. But there is a certain level of personal responsibility that we can't fix, the pro se, because there's a lot of, judges are trained years and years and years. If somebody decides they're going to handle their own divorce case, they maybe looked at Google, for a few months or whatever. And it's just very, very different. But I from what we saw, the judge was incredibly fair. We saw a lot of pro se, very explanatory as far as, okay, you can't present this, or you can, or you have to make sure that the other person has this document too, and even, making sure that they have at least a few minutes to look at it and stuff. But the pro se is really that's the common denominator as far, and I could stand corrected on this, but almost every situation, it's the pro se. So what we can do is, maybe make that recommendation. There are certain things within GAL or other things, but to make sure that they have an easy to read system that's easily accessible, where people can look this up and they're not relying on Google that maybe has information for other states or something, that we have some direct thing that they can look at. But then we can't negate personal responsibility once that's out there, but we can take a better look at what are we giving people who are either by choice or by economics doing the pro se situation, and because that really seems like the common denominator. So
Thank you very much. Representative Ball.
Thank you, Madam Chairman. I do want to just bring up that attorney had told us that 80% of the cases were pro se. That wasn't here, that was on the children and family court. So it is quite large. And it also was brought to our attention when we were in the Nashua court that the courts.newhampshire.gov has informational videos that are available to the general public to go on and learn things, legal definitions, what to expect in a court hearing, what is an alternative to dispute resolution. So there's quite and access to legal assistance in New Hampshire. So there's quite a bit that the court does offer the public, and it might just be that perhaps we need to do a better job in making sure that people know that this is available to them.
Thank you very much for that. I think that that's a good follow-up of Representative Gregg's comments, that the issue of pro se is really a significant issue in terms of what works and what doesn't work in the family court. And added to that is her additional point that individuals nonetheless do have a personal obligation to do the best that they can to find the information that they need when they make the decision to proceed pro se. I do want to, I know that we are, if you're like me, you are drowning in all of the paperwork that we have, including some that I did. I looked at my little home printer and decided that the 385 page report was not going to be printed out, even though I am so old-fashioned that to me the only way you should read something is to have it in your hands. I just don't like all this electronic stuff. But I know that as diligent as each member of the committee has been, you haven't been able to read everything. But there have been some materials that have come to us over time that are quite relevant. For example, Kristen Grant had sent to us something dated June 16th on the application of the rules of evidence in the family division of the circuit court. And it is just a few pages long, but summarizes the major cases that have been heard over the years that demonstrate of how the rules of evidence do or do not relate in the court. And I mean, the one paragraph that I just, for the purposes of those who are listening to today, that I would like to read is: trial courts are afforded broad discretion in divorce matters, and we will not overturn the trial court's rulings regarding property settlement absent an abuse of discretion or error of law. To show an abuse of discretion, the petitioner must demonstrate that the court's ruling was clearly untenable or unreasonable to the prejudice of the case. If there is some support in the record for the trial court's determination, we will uphold it. And I think that reflects the need to understand, with each case being unique, certainly to the petitioners, but also to all the other cases, that there has to be some flexibility in the application of the rules of evidence. And so I just point this out as an example of something, of one of many of the documents that you have that you'll be able to spend some time reading. It's now, looking at the clock, I want to say to you all how very much I appreciate the time that you've put in all these weeks up until now and this morning. And I'd like to, from now until the end of this morning's session, see if we can identify just a few major components of our discussion that we might want to do some digging into between now and September. Representative Kotek.
So if I may, thank you, Madam Chairwoman. I did break up kind of what everybody said into 2 pages, one being legislative changes and one being possibly like things that we might be able to work with the court for, you know, kind of more best practices. It might be court things, but not necessarily legislative changes. So I kind of wrote them all down, and I wonder if I can maybe go by topic and we could say if we do want to move forward with it, and if so, like who maybe wants to work on that. Would that work?
Sounds like a great idea.
Okay. So the first one that was raised was GAL and the role of GAL. And I know that you had raised that, Rep. Greg. So if we still want to look into that, if there's those who might want to.
Could I ask, could you read them all first? I'm so visual. I mean, I'd like to know how many,
Yeah.
I mean, or just give me, are there like 12 on each
absolutely.
side, or what are?
So for legislative changes, this is what I have. So the role of GAL, the neutral case evaluation, possible expansion of it, family law training / continuing education for judges, the presumption of shared parenting, child support guideline fixes, timelines for cases, and then visitation for at-risk kids. And then on the court rules side / best practices side, I have looking into potentially staff helping with forms and pro se parties, the one judge, one family being enforced. You had mentioned broadly just kind of best practice guidelines and that being explored. And then rules of evidence / discovery regulations, you know, being enforced and more widely available. So that's kind of what I have on both sides of the list. Did I miss anything?
Just looking at the, oh, sorry, can I talk?
Go ahead.
Thank you, Madam Chair. Just looking at that, I don't know if that falls into the forms or whatever, but kind of looking at the system that they have, because there is a national like recommendation for family courts and stuff as far as what kind of information they help for like pro se litigants. So that would be something, I guess that would be a best practices. Does that fill in with are you doing that as part of staff helping?
Yeah, so that was on the first thing, like with the forms and the pro se parties. That is on the first. That's the first item on the court side of the
Okay,
list, but not
thanks,
the legislative
Representative.
side.
So-
Representative Macbeth?
Thank you. So one question I have about the topics listed, and I didn't get them all written down, is some of them were mentioned here and they're important policy issues, but they're not to our charge to look at specifically the family division. So I think those things, I mean, I actually would kind of like to look at them all. I mean, like reviewing child support guidelines, that is a huge thing. And that's not the family court division. That's the legislation. I mean, that's policy, you know, somewhere beyond that. So I'm not sure.
Well, that's, this side is legislative changes, so these are like possible policy changes that we would make with bills, versus this is more just recommendations for the court that we might recommend to them, but we're not going to put this into legislation. So I do agree, like this is the side that may be fixed with a bill, versus this is not going to have legislation with it.
So could you,
So there's 7 things on the legislative side, and then there was 4 main areas on the court rule side. So we're looking at like 11 things here.
Look,
So I've
go
got
back to the legislative side.
forms, one judge, one case, best practice, and what was the fourth?
Rules of evidence.
Okay, so,
/ discovery regulations.
oh yeah.
Okay, and
Thank
the
you.
other list?
The other list was the GAL rule, the neutral case evaluation expansion, family law training / education / continuing education for judges, the presumption of the equal custody, child support guidelines, timelines for cases, and visitation for at-risk kids.
So several of those, several of those are things like the GAL role, the expansion events. Those are really, I would put those on things that we could talk about because they have to do with staff and and also the role of the GAL. I went to a case. There are parents that really need guardian ad litems that are not getting them because they can't afford them, and children that are in insecure and unstable places because of that. And I think that judges don't have, by seeing people, I mean, they really would benefit from that outside of court, view. So, I mean, that's something, but again, but things like child support guidelines, I mean, we probably need to narrow that more if we're talking about legislative, but that is a big thing.
They are big, and I was looking to see like if we want to take on like some people that want to take these on, so we can kind of out of our subcommittee like who wants to take on which piece. And I think the GAL piece certainly can be legislative, because we did just have legislation that had passed through our committee. It was a Senate bill, but that was giving the indigent folks access to mediation services without having to repay them. So that can certainly be something that's added legislatively, GAL wise, that could be paid, and that could be something that's in statute that is paid. So I do think that are you saying that doesn't belong on the legislative side?
I was saying that's a big issue, but I can see when we break it down underneath, there are issues that I think the legislature is the appropriate authority.
Okay.
But yeah.
So do we want to go through
So
the
let's
list
go
and
through
people
it
say like which one
And
they want to
see,
do?
okay, GAL, who would like to, not surprisingly, Representative Gregg and Representative Long have indicated that they really want to look in all aspects of GAL. And here we have to remember that the reason it's on the legislative side isn't just policy, it's dollars. And we had for many years paid for this, and when we stopped paying for it, we if you think of this as a seesaw, one person on the end of the seesaw fell off, and so it very definitely is a legislative policy. The neutral case it probably comes down to some different problems, including people who would carry it out. But I could see it as a legislative issue if we were to, in some ways, without violating the separation of powers recognize the important role that it could play. Is this something that anybody would like to okay. And of course, all of us can pursue all of these and anything else because we'll come together in the fall and compare notes and see where we are and what we want to do and where we're going to go. So none of this is restrictive in any way.
So, yeah, I think I'd like to reserve and think about it and tell you what I
Absolutely.
specifically like.
When we get to the training, I wonder why you put that on the legislative side rather than on the judicial side.
So I need to look back, but and see if it's on the OPLC side or if it is legislative. But I do know, like for doctors, they have a requirement for continuing medical education, and they can't re-get their certification unless they've done that. So I would think that it could be a same thing for judges, where they have a continuing law training. But I do need to see if
I
that
don't
is
think
something
that's so because we're looking at the three branches of government. We're looking at the judicial branch as a different branch. The legislature does not play a role in determining who is going to be appointed to the courts. And it is the Judicial Council and other institutions, I would think, that are responsible for the training, for education, and certainly for supervision and accountability. We do know in cases where judges who have behaved inappropriately have been removed, they were removed because it was someone in the judicial branch who brought forward a complaint that was then heard by the Judicial Conduct Committee and acted on and whatever. So I guess I'd have to be convinced that that belongs on the legislative side. And if somebody disagrees with me, I would welcome the disagreement because these are all so complicated.
I moved it over. I agree with you after you've spoken. Thank you.
So,
Representative
if I could on
Long?
that, this is on the training, you moved it back to the
The court side.
To the
court side. So with respect to attorneys having to get,
Attorneys are
Certain
not
courses
licensed
that-
by the state government. They're licensed and disciplined, and their education requirements are the New Hampshire Bar Association.
okay, so it's not
Different
OPLH.
than
or-
like physicians and nurses. I mean, they might be the medical
Right.
association.
And the Bar Association is
I think they're,
part of the judicial branch. It is not an independent body as it is in some states.
So legislator would only have say in whether we were going to elect our judges or nominate and appoint them.
Right.
However, their qualifications is not in our hands.
And that's right. And
Okay.
I don't think there's anybody on the Supreme Court now who has ever had any experience in family court. There are some people on the Supreme Court who haven't had any experience in court. There are, and in family court,
I thought Judge Marconi had family law experience.
maybe,
no.
maybe.
I don't,
So training is on the judicial.
I would say, and accountability. I mean, unless the legislature were to move to impeach, to charge a judge what the House would do, and then the Senate to try the judge, the legislature would have no involvement. The Constitution gives us that responsibility, and in my 25 years, that basically happened once. So in terms of removal of a judge, generally the judges who are removed have been removed through the Judicial Conduct Committee.
I may just be being defensive for the profession, but I can't remember which governor it was. I believe it was 15 or 20 years ago. But whatever governor it was did give up considerable political power when there was established a judge screening process, nomination process, low level, and goes through different committees. And then those recommendations are brought forward to the executive council. So I'm not saying that politics plays a part in everything. But I think that there has been a more recent, a contemporary change to limit the way politics plays and how, or maybe how many people can play into it. But I don't, we should educate ourselves on that. We should stay away from it. But I don't feel like politics is a significant factor in dissatisfaction with judges that or the judicial decisions that we've been hearing from.
Thank you, Representative. But I haven't heard anybody suggest that it was politics. I will point out that you're absolutely right that there was a governor who insisted that we use a system more parallel to what the federal government does in having a screening process. But the incumbent governor has changed that and does not rely on an independent advisory body for nominations. It's a different system. So that, that does change, which is not to say that it's partisan political. It's just to say that it's a different system. Okay, next. What are we up to on your list?
The equal/shared custody.
Okay, now here's my question.
There is a retained bill on that, I know, in the Family Law Committee, so I'm not sure if there's already people assigned to work on that.
Representative Ball is already working on that. She'll be on the subcommittee, so I would put her name in.
So,
That's
well,
it
so
by
then
here.
the shared
I would put her
parenting,
name in.
the shared parenting is a policy of the Children and Family, would go to the Children and Family Law Committee, so that shouldn't be on our list.
Actually, they have, we were just assigned, the people on that are, I think, I don't even see it now. Now I'm looking. But I know it's Pearson, Ball. Is that the one we're all on?
We're talking about shared parenting. So Representative Ball, who's working on that with you?
Actually, that's,
Oh, our researcher can tell us that. Okay, so the shared parenting is Pearson, Ball, Gregg, Long, and McMahon? Okay. 1, 2, 3. Okay, so that's shared parenting, and so that I think that that's handled by Children and Family, not by us.
I believe that's House Bill 185. Yeah, so you have Long, Moulton, Levesque, Seidel, Bickford, Nelson, Panic.
Okay, next. So I would move shared parenting if everybody agrees that that belongs with Children and Family, given the existing bill. Yes? Everybody comfortable with that? Anybody uncomfortable with that?
So I guess I would say I think they kind of overlap because I do think it still belongs here. And I know other special committees have then kind of taken over a bill, and I'm fine with that bill staying in there. I just think we should keep a watch on it because I do think it's very important to what we're doing. So I think I'm okay with them doing it, but I think we should just
I think that's a very good point, and I think in our summations, we should identify this as an important area that is being pursued by Children and Family Law. Does that make sense to you? Is
perfect.
that okay?
I was thinking that the Children and Family Law members of this committee would be
Right,
seeing that, just like
Okay.
judicial may have other things that they.
okay. Okay, next.
So regarding the rules, I did actually just pull up RSA 49F:6, and it does actually have in here that judges assigned to the family court shall be subject to the following considerations: the knowledge, commitment to, and expertise of the judge in the subject matter of the particular division which the judge is assigned. So there is legislative statute about requirements for judges. So I don't think that having the training for the judges is completely out of the realm of legislation.
Okay, Let's see what happens. As long as you have it, what is the RSA?
490-F:6.
F? As in
Yeah.
Frank?
F as in Frank.
Okay.
So we can look into that after. I can go on to the next one. So the next one was child support, which I think is going to be the same situation where we'll watch that bill because there is a bill in the family court committee that they retained, right?
Children and family?
Children and family.
You have a child support bill?
I didn't think we did.
Hmm?
I didn't
What?
think we did.
Wage garnishment.
Oh, okay. So then maybe we should look into that separately then instead of the wage guard. Let's do that separately.
So wage garnishment would be the children and family law.
But I think we
But-
should look separately into the area because I think it's much wider than
Okay.
just that.
That would be House Bill 618.
I'm sorry, I didn't hear.
House Bill 618 is the
618,
wage
thank you.
garnishment.
So I think we might need an additional bill in addition to that. So
Okay, yes. Next.
timelines for cases.
Okay, and
We do have statute on some timelines, and then there's some that do not have any statute associated with it. So I think that that's overall something that we can look at what does currently have statute, and then maybe what needs to have statute, so that we're making sure that, you know, these cases are resolved within a certain amount of time, or at least that there's within a certain amount of time that there's a parenting plan established that's making sure that both parents can see their children.
well, I don't know. I mean, I think at the moment it's this committee, and then we can, there's certainly nothing that I'm aware of that's in the Judiciary Committee that would deal with that. So I think it's this committee. One of the things that I'm interested in about these timelines issue is I guess comes down to the process within the judicial branch where individuals file a complaint and then I'm using the word complaint generically, not as a legal term, and then file a complaint, and then file a complaint, and then file a complaint, and then file a complaint. You do not want to limit the number of complaints that someone can file if there's a legitimate reason for somebody to complain. But what then happens with the timelines? And how does that get handled? And who is responsible then for what could be what someone in a bad mood in the legislature might call dilatory?
Yeah, the issue is, what we heard is the docket. It's very complicating getting the docket set up. So every time for example, we went to a case that had the attorney that the other litigant didn't show up. So there was 20 minutes spent there and they had to redo it. So there's another, they're looking for another spot on another docket. And setting a timeline, if those timelines aren't met, it's complicated setting up the docket because you got the docket set up, I don't know, a week or 2 weeks or longer in advance. Trying to fit somebody in to meet this timeline it's what's complicated. So
I mean, I guess at least, especially for ensuring that a parenting plan is established within a certain amount of time, maybe the whole case isn't closed, but I would like to make sure that within some amount of time, we're making sure that parents are able to see their kids.
Representative
So, so I'm agreeing with the conversation. One thing that's making me uncomfortable, though, is we've identified issues, and I don't see these subcommittee groups going off to find the answer. I'm wanting them to bring back more information so that we can then address them. So if we say timelines are an issue, I don't know that it's for us to create the timeline. It's to really look. Are they an issue? Which cases? What's already established? Why isn't what's already established working? Do we need to do more? And bring that back.
I think we all agree with that. I don't think anybody's going out to search for the Holy Grail. we're going out to say, okay, here are areas that we've identified as problems. What in fact are the problems? How do we define the problems? Do we have balanced information that we're collecting?
So that's, I think.
On the one hand, this, on the other hand, that. And
Because the timelines, we may have ideal timelines, but if we can't get the legislature, or if it happens to be staffing, then that's our issue. So
Right.
I mean, so I will work on timelines, but again, I'm not looking at this as, well, I think the best timeline is today. Well, you know, I have my clients generally say, well, why didn't they rule from the bench? Why didn't they tell me today? So, I mean, I just hope that everybody is, when we look at shared parenting again, and that's an issue that, I think both parents should be treated equally, but I want to know, why do you want to establish the bar? Why is it best to establish the bar if you are 50-50, or what does shared parenting mean? So,
that's going to.
Oh, okay,
go
so I
to
just hoping
Children
people
and
come back
Family
with a,
Law, which has a bill
Okay.
on that issue.
all right, okay, so anyway, timeline.
Representative Ball.
Thank you, Madam Chairman. Another bill that we do have is House Bill, where did I just lose it to? Oh, I think this is the one Representative Long was referring to, House Bill 471, which was establishing the final disposition for the divorce case, and that goes into the timeline. And I think what they were coming forward and telling us is that when they went for their temporary hearing, they wanted something scheduled a year out and put in the docket so that they would know they were in the queue. Because what they were saying is they would spend lots of time negotiating with each other and coming up with an agreement. And then when they went to set the time in the court, it was like a whole nother year away. And so that allowed a whole nother year for now things to bubble up, and now people are going to go after each other. That was my understanding. I could be wrong, but that was something that the Children and Family Law was looking at.
Thank you. Okay, what else?
Visitation for at-risk kids. I know that Rep. Lanza had raised that. I'm not sure if you want to work on that.
Yes.
Yeah, I'll work on it.
Yeah.
Okay, okay, good.
And then the next are the potentially the court rules. So looking at staff and ways to help pro se parties with forms. Rep. Long? Rep. Greg and Rep. Macbeth.
Who said they wanted
Greg and Macbeth.
Greg and Macbeth? Okay, the one judge one.
The next one was one judge, one family. I'm happy to help kind of look into that one. Does anybody else want
I
to
would
join
like to do that with you, too.
in? Best practice guidelines. That was something that you had raised, Rep. Macbeth.
And I think I was talking about coordinating all the different, wasn't best practice for. Okay, I mean,
Oh, was it?
I think-
Was it related to pro se? Because if so, I can take that one off if that's going to be related to the other one we already have.
I think we should all be looking at best practice in whatever area, because I think I was mentioning it when we were talking about police station drop-offs, or even the guardian ad litems, how, you know, meshing them, making sure they're on the same page. And I think it was also, we were talking about a training as well. So, yeah, I think that can be removed as far as any individual.
Okay. The next one is rules of evidence / discovery regulations.
And we do have that June 16th memo that researcher Grant had put together for us that does explain how the Supreme Court has ruled up until now. On, of course, the legislature could involve itself, and
So there is a bill. Rep. Ball's raising her hand. There's a bill in FAM court already.
House Bill
HB.
499.
and what is that?
House Bill 495 is Rules of Evidence in the Family Court.
And that is in this committee, in commit.
It's 499 you have on there, not 495.
499.
Yeah,
Okay,
I usually have
499, okay, and then it is
I'm
in
sorry.
children
No,
and
no, it's
family
just on
law.
here 'cause she goes to church.
Oh,
Okay,
I probably picked it up.
I mean, I would like to look into that, even if it's in children and family law, it's still specifically related to the functioning of the family court. So
Okay.
I think it, to,
okay.
but
All right, and then the final piece is the family law training / continuing ed for judges, which I think can be explored either way because there is under statute something now. So I do think that is something that we could potentially, look at and see which area we want to put it into. And I would like to look at that.
And I would too, so. Me too. Okay, so that's, okay. Very good.
Madam Chairman?
Yes,
Also, there's, I don't know if I mentioned it, House Bill 475. And that also has to do with the right to submit evidence, testimony, and family court proceedings. And that's also in children and family law.
okay. Well, clearly, there's going to be a lot of overlap between the work that Children and Family Law Committee is doing. And there's no need for this committee to reinvent the wheel, but the reason that there are 5 members from Children and Family Law and 5 members from Judiciary is for, is demonstrated in the fact that there are these bills that are pending in Children and Family Law, any number of which bills were part of the impetus to create this special committee. So we want Children and Family Law to do their due diligence, but there also clearly there's a role for this committee to be involved. Representative Long.
So, thank you, Madam Chair. So the timeline is what I'm looking at. I wouldn't advise Children and Family Law to come up with solutions that in this committee come up with different solutions. You know what I mean? So what's that timeline? I know we're looking in September to start subcommittee work on our bills.
Yeah, according to the email that I received, it was going to be Chairman Pearson, myself, Representative McMahon, Representative Gregg, and you that were going on those particular 475, 499, and 471.
Okay, so I'm looking for the timeline as to when we're gonna start discussing those in Children and Family Law, and when is this committee gonna come with some discussion and suggestions?
I think
According-
answer. Oh,
I'm sorry, I was just going to say, according to the email, it said the groups will formally meet in the fall.
So I think for us though, we can informally kind of take on some of this work in the summer to look into stuff and maybe come up with some solutions to present to the committee in the fall, but that we're not actually doing any work because we can't in July and August.
We may or may not come up with solutions, but we may come up with a clearer description or definition of the problem that might need solutions, and that we shouldn't begin by assuming that we know everything there is to know and that we know X is right and Y is wrong, because there's just a lot of complexity in all of these issues. I also know that there are a number of national institutions which have looked at these issues, have evaluated what's going on in different states. I know Representative Gregg has mentioned several of them. I have looked at some of them. I'm sure some of the rest of you have also. And I would hope that during the summer, when you're not sitting in a lounge chair eating chocolate bonbons and reading mystery stories, that you might want to look at what some of the national resources have suggested about these issues, and recognizing that sometimes a national suggestion or solution doesn't apply in New Hampshire. We tend to march to our own drummers, sometimes with good reason, sometimes without good reason. But I don't think we should assume that we know the outcome now, or at least I would hope that we don't assume we know the outcome, that all we know is that these are problems that bear looking into. Is that a fair assessment? And of course, Chairman Pearson's going to want to be involved and exert his leadership role in this. But that will not happen until the fall. We will give him, he'll be able to watch this if he isn't watching it at the moment. And we'll give him a very detailed report of what we talked about, but understanding that it's just giving us an opportunity to come back in September and say what we did with our summer vacation.
Can we circle back to a few that didn't really have many people like working on them and see if anybody else was interested now that
Sure.
we've gone through everything? So the neutral case evaluation expansion, I was the only one who had interest on that one. Does anybody else want to?
I'm interested in that, Representative Macbeth.
Okay. So Ball and Macbeth. And then what about child support? Because I think that's going to be another really big one. You'd like to help? Okay. And I think everything else. Oh, so
Who said child support?
Rep Ball.
Ball.
I think the only other one that there was nobody else was the rules of evidence / discovery regulations. I know there was some retained bills. Rep Macbeth, you indicated that you'd also like to be a part of that. Is there somebody that's on all of that in addition? Oh, Rep Greg, Rep Long, and yourself. Okay.
I believe what I heard Representative Ball say is that on those bills that relate to the work here, all of the Children and Family Law members of this committee are on those bills.
Okay.
If not all, good representation.
Right. Yeah, we've just been told that the LSR filing dates are September 11th to 15th, but that doesn't apply to this committee. Special committees can ask the Rules Committee at any time for bills. It does apply if, for anybody who on their own want to come in with their own legislation on these bills. The bills that are retained have to be out by November 17th, and that would be about the time that we would want to have a final report. Anything else for the good of the group that we should talk about now? I really am incredibly appreciative of all the time that people have put into this. I think everyone on this committee has taken it seriously. It's a complicated issue. There are no easy answers. And we will come back in the fall. Obviously, some of us will chat informally with each other, but in no way that conflicts with our commitment to 91A. So we will not be, conducting business. We might be talking about scheduling. We might be talking about other kinds of things. And we will meet again at the Chairman Pearson's control when he announces what our first meeting in September would be. But if there's nothing else, I'd like to again thank everybody and hope that this work session helped us understand how complicated the issues are, how many problems there are out there for which they're likely not easy answers, and that we will return. And we are adjourned. Great job. Thank you. I'm not sure.